So once everyone's finished those vital conversations, my name's Helen Stacey. I'm a senior fellow at Stanford's Freeman Spogli Institute for International Studies, where I direct the program on human rights in the Center on Democracy, Development and the Rule of Law. The panel now that we have is going to reverse the optic of the last two previous panels. The first panel yesterday began with the human rights movement as a global movement. This morning's focus was on CEDAW, and now we're going to flip the analysis and ask what, if anything, have been the effects upon the general international human rights movement as it takes place in various locations of the women's movement. The first thing you might like to do is have a look at the title of the session and note a couple of the assumptions implicit in the title. First assumption is that it's a global movement, that the human rights movement is a global movement. I suspect that what you hear this morning might give you pause in thinking that it's global. Or if it is global, it's certainly highly differentiated. And then the use of the word equality always gives me a moment, because the hanging pregnant question there is equal with whom? And why should the benchmark be with that whom, however that whom is denominated? And I know that the panelists that I have are going to use some of their own examples working in the women's movement in their own ways and make some observations about the effects, backwash, spillover, whatever that might be, on the human rights movement generally. So let me introduce the panelists, and then I'll tell you about the process that we're going through. We're going to follow, by the way, the order that's in your program. To my direct left, we have Rangita de Silva de Awi, who right now is a Woodrow Wilson International Centre scholar. You've got her full CV there. She also holds many positions at Wellesley College. She comes to us with a SJD from Harvard Law School and has also been a European Law Research Institute scholar at Harvard and has held a position at the Kennedy School at Harvard. The second person on our panel at the end of the table, is Hossam Bhagat, who is Executive Director of the Egyptian Initiative for Personal Rights. Hossam has been in that position now since 2002 and has covered the many fields of rights, healthcare, privacy, and so on. And his qualifications are not on the CV, so you'll tell us that when you first start. Our third speaker is Xianan Liu, who comes to us from the Anti-Discrimination Network of China and also has qualifications from the United States, where she has obtained an LLM from Yale Law School and also an LLB Master of Law and PhD from the Yi'an University School of Law in China. And then last but not least, right here in the middle, is Sawan Zahir, staff attorney at the Adala Center for Arab Minority Rights in Israel, similarly credentialed from all around the world. Let me tell you what they are. She's been at that center since 2005, has an LLB from the College of Management School of Law in Israel, is that right? Yes. And an LLM in International Studies from the American University in Washington, D.C. Here's how we're going to proceed. We're going to go in the order in your program, with each of the panelists speaking for 7 or 8 minutes about what they consider their central message to be. And then we're going to conduct a conversation up here between the five of us and open the floor to Q&A. So with that, Rangita, please kick off.
Thank you. My central thesis is that the architecture of modern international law has been ineluctably and indelibly shaped by the global women's human rights movement, especially by the women's movement from the global south. And this contrasts with the traditional narrative that international institutions are Eurocentric or emphasizes the role of the state. So first, what are the key values of the global women's human rights movement? The first to me is the way in which the global women's movement dismantled the artificial dichotomy between the public and the private. Historically, as we know, international law has regulated state action. And the women's movement, for the first time, dismantled this dichotomy, the public and the private, which plagued both international law as well as national law, by showing the way in which private acts of violence, such as domestic violence, marital rape, are public crimes, and therefore within the jurisdiction of international jurisprudence and national laws. And for the first time, a human rights convention covered the private sphere, including individual action and not just state action, thereby revolutionizing international law jurisprudence. For example, Article 2 of the CEDAW, for the first time enshrines, and this is unique for International Human Rights Convention, language that covers discriminatory acts by a person, organization, or enterprise. So the ways in which international human rights law came to cover individual action revolutionized the landscape. It has never before been the ambit of international human rights that individual action in the private sphere became under the jurisdiction of international human rights. Secondly, Article 5 of the CEDAW calls for the modification of social and cultural practice, including the elimination of prejudices and customary laws. At the close of the last session, there was this question about how do we change the hearts and minds of people, the culture, and that law reform alone is inadequate. And I think what the CEDAW does is really make the changes in cultural practices and traditional practices central to women's human rights and to a global movement. And this has been used in very strategic ways by the women's global movements in striking down and challenging customary practices and traditions that violate women's human rights. Just to give you one example, in Nepal, the Chaupadi practice calls for menstruating and lactating women to sleep outside in the cowsheds because of alleged reasons of cleanliness associated with menstruation and lactation. The women's human rights movement mobilized around this cultural tradition and used the CEDAW, the Article 2 of the CEDAW, to strike down this cultural practice. Similarly, in Pakistan, the case of Humaira Kaku, which really revolutionized the landscape of child marriage as well as forced marriage, was struck down because of the use of the CEDAW. Again, the traditional practice or the customary practice of forced marriage, child marriage, was declared a public crime and not a private act of custom or tradition. Similarly, in Nepal, virginity testing that was allowed for under the Muluku Ain or the civil law as a custom was struck down because of the provision in the CEDAW which called for changes in custom, tradition, prejudices, and bias. And this was once again revolutionary for international public human rights law. The second value that I think animates the global women's human rights movement is the way in which the local has shaped the global. And that is a value that is especially pertinent to domestic violence lawmaking. As the first UN Special Rapporteur on violence against women, Radhika Kumaraswamy, has stated, perhaps the greatest success story of international mobilization around a specific human rights issue, which led to the articulation of international norms and standards and the formulation of international programs and policies, is the domestic violence movement led by the global women's rights movement. So the ways in which local resistance movements shaped and informed global lawmaking, policy reform at the United Nations level was so very clearly and powerfully seen through the lenses of the work of the global women's human rights movement. And as Saskia Sassen has stated, because these women's movements understood the cultural, social, and political setups on the ground, they were able to, in very context-specific measures, shape international law. The third element is the way in which the global was translated and transformed into the local. And this was done by the global women's movement in very strategic and powerful ways in which they saw the steps leading to the translation of the CEDAW values into national and local lawmaking strategies. And what we see is how post-Beijing, the Beijing Platform of Action, as well as the CEDAW, as well as the Declaration on the Elimination of Violence Against Women, were used as blueprints, as what I would call standard-setting documents to shape laws and policies on the ground. And we see that also that the global to local was shaped by transnational women's movements. And the ways in which women forged connections beyond boundaries and borders really shaped the ways in which laws and policies were drafted at the national level. So, for example, when the Philippines Anti-Violence Against Women law was introduced in the Philippines Parliament, the Senator Estrada, who introduced the bill, declared that this law is an offshoot of several initiatives in other countries and their contributions and their commitments to end domestic violence law. So she acknowledged and celebrated the ways in which the women's movement borrowed from transnational engagements and from jurisprudence in other countries. And that is also something very, very pertinent to the global women's human rights movement. And fourthly, the ways in which the women's human rights movement has strengthened access to justice and the rule of law. In the past 50 years, we see that because of the global women's movement, 139 countries guarantee gender equality in the constitutions, 125 countries outlaw domestic violence, 117 countries outlaw sexual harassment, and 117 countries have equal pay for equal work laws. It might be still in the realm of rhetoric and legal reform. But as we discussed earlier in the morning, law reform is constitutive and standard setting and normative. And that is the first step for any reformist project or initiative. And the ways in which these laws have strengthened not just the articulation of laws and rights, but the whole landscape, the legal landscape, and the rule of law, as well as access to justice, is once again a unique value of the global women's human rights movement. Fifthly, the ways in which the international human rights norms have been articulated and invoked in laws that have been shaped by the global women's movement is also very unique and very important for us to address. So what we see is that in countries that have recently adopted and promulgated domestic violence laws, the preamble of these laws invoke these human rights norms and standards. So the Indonesian law on domestic violence, the preamble itself says that this law is in compliance and is compatible with human rights, including the UDHR, the CEDAW, the CRC, and the ICCPR. So the invocation, what it does is that it holds these laws to a higher standard and privileges the supremacy and the primacy of international human rights law. And what would happen is that when there is a conflict in national laws, the international human rights laws will prevail in a court of law. And that is another value of the global women's human rights movement. And I know my time is coming to an end. Very quickly, accountability, state accountability for inaction. So under the due diligence principle, which has been advanced by the global women's human rights movement, especially in violence against women, where even though violence against women might take place in the private domain, the fact that the state may not be directly responsible but would have indirectly contributed to this violence because there was lack of due diligence or lack of state responsibility in addressing violence through strong law enforcement gave rise to this concept, a vibrant concept of due diligence, which now has been mainstreamed through domestic violence lawmaking like the Maria de Penha law in Brazil and other laws that invoke due diligence as important state accountability provisions. And finally, what I see as being one of the strongest elements of a global women's human rights movement is the ways in which human rights norms have been used as powerful organizing principles. So, for example, in Morocco, the 1 million signature campaign to reform the Mudwana or the family law was again led by the global women's movement, using the CEDAW as a way to bolster this campaign. And these campaigns have spread like a virus to other countries. Lebanon is using it. Jordan is trying to spark a Million Women campaign to amend citizenship laws. In Iran, this has spread to Iran, where the Iranian women's movement is using this as a best practice to create a campaign to reform the Iranian family law. So campaigns and litigation using human rights norms as interpretive tools to fill the gaps in the national laws. And we see that as a very vibrant tool used in the Indian Supreme Court by women lawyers who have, when national laws don't speak to or are silent to certain issues, such as sexual harassment, in this very, very paradigmatic case of Visakha versus the state of Rajasthan in India, where India lacks a sexual harassment law. In the absence of such a law, the women's groups used the CEDAW to fill in the gaps, to use the CEDAW as an interpretive tool to say the fact that India has signed on and ratified the CEDAW ensures that the CEDAW would fill the national laws, and that Article 2 of the CEDAW on equal protection is really cannot be fulfilled. It will be futile unless women are protected in the workplace and at home. And therefore, sexual harassment was declared a discriminatory act, both under the Indian Constitution and the Convention. So finally, the intersections, the intersectionalities, the ways in which the CEDAW has been used by different movements to promote the fact that women are defined not just by their gender, but by their race, ethnicity, religion, caste, and places of residence, has been enormously powerful to other human rights movements that are using not just the CEDAW, but the CEDAW in conjunction with other human rights treaties to advance an intersectional understanding of women's human rights. Thank you.
Thank you, Rangita. Hassan, the floor is yours.
So I thought about the question posed to us for this panel and the introduction as well as invitation by our moderator to reflect about the question, as well as Rangita's comments just now. And all of this has inspired me to do something that is extremely controversial right now, which is being the only boy on this panel to actually first of all, introduce myself as a women's rights advocate, as a gender equality advocate, and to invite us to maybe spend a few minutes in this symposium engaged in some self-criticism, self-reflection as a movement. I think the panels have been wonderful so far, but I think there's been a certain degree of celebration, and I think it's due, it's well-deserved. But I think it's also helpful to think about where the gender equality movement, the women's rights movement, has fallen short, or maybe rephrase the question for this panel so that it's not what others can learn from our great accomplishments, but what mutual learning can we introduce between different movements. And one of the things that, okay, if I need to, in order to justify this, establish some credentials, then you let me know. But
You don't have to be defensive, We want you here.
Yes.
Now you're intimidating me.
Well, you did call yourself a boy, and we're all women.
It's true. I sit on the board of Egypt's New Women's Foundation. On the advisory board of Sexuality Policy Watch, which used to be the International Working Group on Sexuality and Social Policy. I was on the International Planned Parenthood Federation's panel that drafted their sexual rights charter, et cetera, et cetera. So I really care about this issue. And one of the things that struck me because of conversations that we've been having since we got here is the issue of hearts and minds, what we can call the challenge of gender and democracy. And when I think of the women's rights movement, it's obviously a movement that is, in Egypt at least, much older than the human rights movement. We trace the struggle for gender equality, for women's rights in Egypt to the late 19th century, early 20th century, so we're talking about over 100 years, literally, whereas the human rights community in its current manifestation, as we know it today, is something that we've had since the 80s. And one of the things that strike me when I read the literature of the great advocates, men and women, who advocated for women's rights in the late 19th, early 20th century is how much they targeted the people, the hearts and minds. So, and how much they managed to achieve. If you think of things like girl education, for instance, or allowing women access to universities, or the campaign for lifting of the face veil, for instance. Of course, these things came with a lot of struggle to force policymakers to change policies on them. But really what I see as the greatest accomplishment is how public opinion was changed, and how that came at a great cost to, of course, the first generation of advocates that worked on these issues. There is something that changed with, of course, the emergence of the post-colonial national state, in that state made a deal. We're going to be we're going to not only end the occupation but also achieve renaissance in a way, and now the state is in charge of implementing the Enlightenment project, which means that the state is going to give women their rights, and in return the state is going to confiscate, monopolize, or co-opt any civic space that existed for independent movements. And so we see with the 1950s the end of Egypt's labor movement, student movement, political opposition movement, youth movement, and women's movement, unfortunately, which was, it became one of the prerogatives of the state. And so Egypt then grants women their right to vote in 1956, and then the women labor rights are again granted, and we see these accomplishments as, of course, results of decades of pre-republican, pre-revolutionary struggles by the women's movement. But we see that granting these privileges or rights coincides with a demise of the independent women's organizing around the same time. And like I said, that applied to many other civic movements as well. With the re-emergence of independent women's organizing in the 70s and 80s, and certainly in the last few years of Mubarak's rule and the last 2 years after unseating Mubarak, there is something. One of the challenges that we're facing right now is really going back to the fight for the hearts and minds as the primary source of change, because the progressive dictator who was friendly to women's rights and child rights, but horrible to everyone else, and his first lady who was spending her time advocating women's rights and conspiring to get a Nobel Peace Prize one day, while she remained silent on everything else that her husband was doing. They're gone now, and with them, where there is an incredibly open political sphere and a very vibrant media sphere, and we have to fight, the early fight, really. We have to start from, I keep cite this, if you look at all the public opinion surveys that were conducted in Egypt after the revolution, Pew, Gallup, or Egyptian surveys, you will see that the percentage of Egyptians that believe that men and women are equally entitled to the same rights is around 40%. It goes up or down, but it's 40% of the people. And but the majority of Egyptians, much smaller percentage than 40%, believe that if jobs are scarce, that women and men should have an equal shot at them. The majority would always answer the question that men should get the jobs in light of unemployment. And then Egyptians that believe that women are fit to become presidents is, of course, an even much smaller percentage. That is the fight right now, and that's part of the challenge, is to, on the one hand, we don't want to reopen or to even open a debate about equality, of course. Because as advocates, we start from the premise that, men and women are equal. All human beings are born equal, and we don't want this to be a subject for a debate. But at the same time, we need to communicate why we think that women are subjected to institutional discrimination, why we are feminists, and what's the impact of gender discrimination and gender inequality on the overall health of our society. And that's one of the major challenges that we are facing right now. Chris Stone, who was here yesterday, he pointed out something that he believes permeated the human rights thinking, which he termed it as seeking, as rights advocates, we seek the triumph of rights over democratic processes. We believe that our cause is right, and we believe that we are fighting for equality and for a good cause, and that sometimes, without acknowledging it, we think of our challenge as a challenge to defeat what could be a democratic majority that disagrees with us, and how do we make sure that the democratic process is ended? How do we make sure that the ballot initiative is defeated? And that's, I think, also one of the lessons for mutual learning for all of our movements, what to do when you know that public opinion is not yet on our side, but that if you wait for public opinion to turn, there could be damage, there could be lasting damage, and of course countless victims. Whatever I said about Egypt applies to Tunisia even more, because Tunisia had the most liberal, of course, women's rights and family laws in the Arab world. An interlinked challenge quote lesson is, of course, what to do with Islam, what to do about Islam. And I just, I'm not going to get into great detail, but I think what Zaina and Sisters in Islam and Musawa are doing is absolutely revolutionary, because one of the lessons, again, by way of self-critique, that I think both the women's rights movement and the human rights movement should learn from the past decades is that political Islam is not going to disappear if we keep looking the other way and wishing it to disappear. That we need to engage Islamists, and we need to engage them on their ground. And what Zaina, is Zaina still here? Hi, Zaina. Sorry. What Zaina did not, Zaina, of course, spoke very eloquently about the opposition and criticism and challenge she's facing from the Islamists. But what she did not mention is that she is equally hammered, if not more hammered, by the feminists, the traditional feminists, the old guard of secularists for engaging with the Islamists using Sharia. Whenever we did this, and I'm sure Zaina has the same experience, we are told that we are responding to religious discourse. By religious discourse, we are just injecting the public sphere with religion. What space is left for non-religious or for secular discourse? We are being dragged on their ground, and they are better educated at this than us. That we are contributing to further Islamization of the debate and the discourse, whereas women's liberation could only come with the defeat of the Islamist project. And of course, we now see the result of decades of doing this. Those that, in the past, it could work sometimes because the discourse of enlightenment or modernity was sponsored by the dictators. Now the dictators are gone, and it's our discourse versus theirs. And unfortunately, we don't have enough diversity or enough capacity, even enough knowledge. And Zaina, it's not about the Arabic. We are native speakers of Arabic, but it's a matter of having the tools, the terminology, the right discourse, and the right arguments. And it's something as simple as really using existing literature. As you, again, very eloquently said, it's not about conducting research in Sharia. There is research that is out there that would give us enough arguments to, not just on women's issue, but to argue on a moratorium on the death penalty, recognition or the rights of non-recognized religions, issues. As I mentioned yesterday, we at some point had the approval of Al-Azhar for a bill that would have legalized or decriminalized abortion for victims of rape and incest. And all of this could be done using existing research if we choose that as a strategy. So communicating women's rights as a social justice issue and reaching, or targeting the public as a social movement, as a social change project, rather than a lobbying activity, rather than a policy advocacy project to get the policymaker to change that law or change the language, is a challenge. Communicating women's rights as part of the revolution's agenda. Our revolution had the motto of bread, freedom, human dignity. Unfortunately, very often we found ourselves trying to squeeze gender into the discourse around the revolution, rather than being comfortable saying, women's rights and gender equality were at the heart of this revolution from day one. That's also a challenge of communication, and of course, my final point is, about storytelling and narratives. Which women do we talk about, and what rights do we mean when we talk about women's rights? And I will conclude by saying that a big part of our challenge is to present women as agents of change, when what's more effective in terms of winning public opinion is to present women as victims, and that's something that is also very difficult when you have a public opinion internally but also externally that is predisposed to sympathize with the poor women that are oppressed by the new Islamist rulers that need to be saved by us. It's extremely difficult then to present the cases of female demonstrators that were subjected to virginity testing without by the military without really presenting them as victims. In fact, if you read the story, this is a 25-year-old veiled woman from the south of the country that is suing the field marshal who replaced Tantawi. That's an incredibly heroic move. And even though she lost at the military trial and the prison doctor was acquitted, we're still representing her in a case that has now gone before the African Commission on Human Rights. That is not a weak victim. In post-revolutionary times, it's very difficult to present, female labor unionists, small farmer unionists, women domestic service workers that are becoming organized for the first time and say, these are the heroes of the revolution. They're not just, the women that are running for national parliament or sitting on the Constituent Assembly drafting the Constitution that are these heroes. And at the same time, we're finding it very, think of how many articles you read about Egypt in the last 2 years about female genital cutting and the risks of a return of that practice after Mubarak. And then think of how many articles you read about maternal morbidity in Egypt and the levels or the services that are available in post-revolutionary Egypt. There will be dozens of articles on FGC and nothing on maternal mortality, because FGC is sexy, it has religion, it has sexuality, whereas maternal mortality is not sexy, and it's incredibly difficult for us to highlight issues in post-revolutionary Egypt that are now seen as small. They are not big enough as, how many women are in parliament, how many women are writing the constitution, how many female ministers. There are issues of, what services, legal services are available to rape survivors, maternal mortality, trans women and trans men that are still subject to the same levels of violence and abuse that they were subjected to under Mubarak, and health insurance for women, especially women that are in charge of households. So my last challenge, question, lesson is really, how do we adopt a holistic feminist progressive agenda when we talk about women's rights that includes both small and big issues? Thank you.
Jianan, over to you.
Hello, everyone. Oh, it's okay. It's okay.
No, I'm not doing this.
I'd like to talk about the lessons learned from the global gender equality movement for Chinese women movement and other human rights struggles. China more and more involved in international human rights framework and mechanism. International human rights concept and useful experience come into China. I think it's very important for China. The country like China, we have very powerful government and small social societies. And also, traditionally, we don't have the human rights, concept and the tradition. So, for example, just the Fourth World Conference on Women in 1995 promoted the development of the research on gender equality and the Chinese NGOs development, especially relating to women's rights. And the Chinese scholars got more opportunities to have a conversation with foreign experts, and also got some financial support from some foreign foundations to do research. And the Ford Foundation actually contribute a lot. And also, especially, for the women NGOs. Actually, in China, before the conference, we don't have the concept and the mechanism of an NGO, because many people think NGO just anti-government organization, and we don't have many space for NGO, but as the host country, the conference, the sponsoring of NGO forum of conference enable Chinese women's organization to be involved in serious of influential NGO events since the 1990s, and introduced the more concept and the mechanism of NGO in China, to China. And here I'd like to take the right of person with disabilities as an example to show what other human rights struggle in China can learn from the gender equality movement. The reason I take the rights of persons with disabilities as an example, because there are some comments between this kind of rights in China. Because I think, in China, the government used a similar way to protect women's rights and the rights of persons with disabilities. In China, we have there are special laws to protect women's rights and the rights of persons with disabilities. The law on the protection of rights of interest of women, and the law on the protection of persons with disabilities. And in China, we also have two special NGOs, All China Women's Federation and the China Disabled People's Federation. They working on women's rights and also the rights of persons with disabilities. Somebody called these two NGOs government-controlled NGO. And also China ratified the CEDAW and the CRPD. We are one of the first countries to ratify these conventions. Also, under State Council, there are the National Working Committees on Women and Children and the National Working Committee on Disabilities. I think in gender equality movement, the concept gender often used to emphasize the social and the culture as opposed to the biological distinction between men and women. And some NGOs relating to the rights of persons with disabilities now in China start to emphasize the difference between impairment and disability. I think, the distinction of impairment and the disability is also very meaningful, and the similar role with the sex and the gender. The CRPD emphasized the reason a person with disabilities is restricted in or excluded from participating in society is not only because they have long-term impairments, but also because all kinds of barriers beyond impairments to prevent them their full and effective participating in society on an equal basis with others. However, the Chinese law instead focuses on an individual mental, physical, or physiological abnormality. I think the two things will result in two different kinds of policy. A disability caused by various impairments under the convention are social issues, and the law and the policy are supposed to target the social impact by lighting or creating an environment to allow the person with disabilities to participate in the society equally. In contrast, the focus on the individual target, the individual's impairment, and it emphasizes on the treatment on body functions or pathological issues. And also, I think in China domestic laws, there are some concepts. Just although we ratified the CEDAW and the CRPD, but there are some concepts actually different with the convention, the domestic law, like I think the purpose of CEDAW is safeguarding the substantive equality between men and women, women's human rights. And the CRPD also mentioned human rights, fundamental freedom, and dignities. But in Chinese law, it still emphasizes like lawful rights and welfare and special protection to these two group of people. I think actually they are different. And although it's a great opportunity, just China ratified the conventions, but there are also some challenges. For example, just the localization of international human rights concepts. How to do awareness raising to make the public understand and accept the spirit of this concept without distortion is a crucial issue. Like gender mainstreaming, discrimination, substantive equality, or reasonable accommodation are all borrowed words for Chinese. And these ideas are different from traditional Chinese culture. And also, just like Chinese academics created two new words, 生理性别 and 社会性别, to translate gender and sex and gender. But actually, it's very few people really understand what is gender and what is gender rescreaming. Also, like discrimination. In Chinese, a lot of things, discrimination just look down upon somebody, but actually it's different with discrimination. In 1950s, Chinese government encouraged women to break the line of the public sphere and the private sphere and go out to work. At that time, just this kind of education is also different from traditional culture. But at that time, the slogans is much simple, like the women can hold half of sky, and whatever men can do, women can do. It's much simple and more exciting. But now, just we always feel confused just how to do the education to the public. Although we joined the CEDAW in early 1980s, but we did the third wave survey on social status of women in China, last year. And the survey shows 61.6% of men and 54.6% of women agree that the field for men is in public, and the field for women is within household, respectively increase of 7.7 and 4.4 percentage points compared with the year 2000. It's just 10 years later, more people think the women should stay home. And also, 44.4% interviewee agreed that for women, good marriage is more important than good career. And it's increase of more than 10 percentage points compared with the year 2000. So the traditional gender awareness and the attitude come back. And for the person with disabilities, the number of large-scale events for people with disability were held following the 2007 World Special Olympics in Shanghai and in 2008 in Beijing. just the actually more and more people start to pay attention on the person with disabilities than before. But in China, we have annual national days for people with the disabilities called Helped Disability Day. And 1 million young volunteers to help persons with disabilities action plan. So I just feel the publicity about disabled people stress on the help given to them by the able-bodied people, and the right and the interest and the ability and the human rights of the disabled people and their contribution to the society were overlooked. I think I used up the time, so I just stop here.
All right, perfect. Thank you very much, and we'll come back. Susan, please.
Okay. I'm a Palestinian citizen of Israel, and I work in an organization called Adala, as Nancy has said already before. Adala in Arabic means justice, and it's the leading legal center for the Arab minority rights inside of Israel. Before I try to answer the question posed in the title of this panel, I would just like to give a brief background of who we are, because sometimes I do encounter I just get into the content of my presentation, and some people don't actually know that there are Palestinians that are living inside of Israel or inside of the Green Line. So I am a daughter to parents and a family of Palestinians that lived in Nazareth before 1948, before Israel was established. And like the other remaining 20% of the Palestinians, they were able, because of many circumstances, to stay inside the territory that became later the state of Israel. Whereas the most of the 80% of the Palestinians that used to live in the area of Palestine then became Palestinian refugees and are now diaspora all over the world. So those who stayed in the territory of Israel were able later on, a few years after the state was established, to get Israeli citizenship. So I do have Israeli citizenship, but my nationality is Palestinian. So actually trying from here to come as well to try from here to answer the question posed in the panel is what happens to women that are part of the trying to be part of the global gender equality movement, but on the other hand are part of a national minority in a state that uses or exercises institutional and intended discrimination as a policy. This policy, as I said, is being intended. I'm not going to get now here to all the details. I invite you to get to our website and read many materials that are being written on how Israel is exercising the institutional discrimination, whether by policies, and unfortunately in the past 3-4 years also by laws. Not only by policies, but also by laws. So we actually, Adala was established in 1996. We used the Israeli law in order to tackle discriminatory laws and policies against the Palestinian minority inside of Israel. And as such, we try as well to use the Israeli case law, the Israeli decisions by the Supreme Court, in order to achieve our own rights, the human rights, and mainly to tackle the discrimination against us. So one of the cases that we tried, actually, we can say that it was an attempt really to learn from the, not global, but from the national gender equality movement inside of Israel, and we tried to implement it on the Arab women that are citizens of Israel. So in 1993, there was a law. I'm going to bring like very tangible and actual cases in order to illustrate why I can even answer negatively the question that has been posed in the panel, because for us there is no global, I can say there is no global gender equality movement, and when nationalism and feminism clash with law and politics, you really can have no option in order to really implement the right, even if you had good legal basis based on the local law and even the international law. So in 1993, there's a law in Israel called the Governmental Corporation, which actually addresses everything that is related to governmental corporation, including appointments to the board of directors to such companies. In 1993, this law was amended to include adequate representation and obligation on the ministries, different ministries, to ensure adequate representation of women in the board of directors. And this was after a huge and massive work done and lobbying done by the feminist movement. And when I say feminist movement, it's mainly comprised of the Israeli feminist women, which led to this amendment, because the rate and the percentage of the women in the board of directors was very, very low, and it comprised only 7% of women in the board of directors back in 1993. So one of the feminist organizations in 1994, after the amendment was confirmed and they saw that the law or the amendment hasn't yet been implemented, and they needed kind of some push, so they submitted a petition to the Supreme Court asking to implement the amendment. The petition was submitted by the feminist organization, which actually is a public interest organization. They didn't bring any petitioner as women that have any qualification, like they didn't have any specific petitioner in order to bring the claims and bring the claims, among other things, that these women are also qualified to be appointed as board of directors. They didn't even specify in what appointments exactly and in what appointments they want the women to be appointed. They just said that there is a law, this law has not been enforced until now, and there is obligation, and the obligation should be implemented and enforced. So the Israeli Supreme Court, of course, it was a huge and great opportunity for the Supreme Court, for the Israeli Supreme Court, to provide a very good, actually excellent liberal narrative on the principle of prohibiting discrimination, on gender equality, especially as a great tool, an important tool in order to tackle historic discrimination against women, especially when we have, when we're talking about difficulties of appointing women and getting to the right women in order to appoint them. But the Supreme Court eventually decided that even if there is any difficulty to reach the women that are qualified, because not many of the women will get to the position ad, or even would know that there are empty appointments in order to submit the application to be appointment. So the Supreme Court said that there is the law, and it is on the obligation, it is an active, positive obligation on the state and on the ministers to do immediate, to take immediate measures and immediate steps in order to enforce the law. Otherwise, there will be no effectiveness for the law itself. So, of course, the results were very good. From 1994 till 1995, the percentage of women rose from 7% to 15%, and each year it kind of doubled. Today we're talking about almost 50%, which is a great. But when we look at who are these women that have been appointed, we see that most of them are Israeli women. So if we do this parallel study or equivalent, we try to find the equivalent, it's exactly like the equivalent of the white women in the US or in the Western countries, or if I would take specifically the US, versus the struggle of the African American. However, of course, historic and political backgrounds make the struggle, the feminist struggle of both movements very different because, as I said, we became unwillingly a national minority in our homeland after Israel was established, and this makes the difference between the Arab feminist struggle in Israel and the Afro-American struggle in the US. Anyway, we wanted to make advantage of this very good liberal narrative and decision by the Israeli Supreme Court, and we said women are women. So in 1994, when we saw that the appointments and the enforcement of the law was mostly applicable only to Jewish Israeli women, we submitted a petition very, very similar to the one submitted by the Israeli feminist group. We also didn't have, like the feminist group, which is the Israeli Women's Center, IWC. Like the IWC, we submitted it only by Adala, the public interest body. We didn't bring any women, and we said there is a law. But the only difference was that beyond, or in addition to the specific amendment that ensured adequate representation to women in 1993, there was another amendment in 2000, which actually came and said that there is obligation on the ministries to ensure adequate representation for the Arab population inside of Israel. So taking as well gender as a suspect class, and then anchoring the national minority as a suspect class as well. And by the way, it's really funny because generally gender as a suspect class, anchoring it in constitution or law, generally would come after a huge struggle, after the national background and the race have already been anchored. So here it's kind of the opposite. But anyway, we already have it as an amendment in the law. And so we based our arguments on the IWC case, and we said we're talking about law and enforcement, we're talking about enforcement of the law, we're talking about women as well, we're talking about case law that we already got because we're in a common law system back in Israel, and we're talking about two amendments that ensure for women and for Arabs the appointment to the directors of the boards in the governmental corporation. So what happened? This was in 2000, and in 2003 we got the decision where the petition was dismissed. The decision was dismissed because a few reasons. First of all, the court didn't accept the fact that there are no specific women as petitioners, if you compare it with what happened in the IWC case. The court said that because we're talking about Arab women, the duty and the obligation is on the petitioners themselves, on the NGO, to bring a list of qualified women in order to prove that, and in order to bring them and show them to the ministers, that in order that they would be able to pick from them the qualified women. In addition, despite the fact that we have the obligation on ensuring adequate representation for Arabs and for women, still the question that is being posed is what is the pace of appointing women that the ministers should meet with? Is it a reasonable period of time after the amendment of the law, or is it an immediate measures and steps that they would take? Again, these questions were never posed in the IWC when the general and the national global, the National Feminist Center was posing the petition and was arguing in court. So eventually, what's interesting here for us as well is that when we try to implement the achievement of the national feminist movement in Israel on Arab women, so we took the universal approach. The court came and made the reverse back to the cultural differences, because one of the reasoning of the Supreme Court in this decision was that you cannot come and expect from the ministers to come and immediately implement such a law when we are talking about Arab women who have their own cultural differences, who have their own unique issues. So when we try to get rid of the cultural differences, the Israeli court itself try to bring us back to the same cultural differences. Nowadays we are drafting. I am drafting another petition that hopefully I will submit very soon to the Supreme Court, which will be the continuing. It's going to be a new petition, but it's going to continue this issue because the idea here is to tackle as well the implementation of the law, and also pose the question, because the state in 2003 in the decision said that the Attorney General claimed, we don't even have any obligation to come and implement the law when we don't have a specific amendment that relates to Arab and women. Like if we have the amendment for the Arabs and the amendment for the women, this doesn't mean that it relates to Arab women. Okay, so I'm trying now to tackle this implementation and the applicability of the two amendments on the specific group of Arab women, and as well tackle what has been posed in the decision of the Supreme Court as the pace of the implementation, claiming and arguing that even, because I cannot come and critique the court when I am writing a petition and saying that you were wrong. I cannot do that, especially that we don't have any option to appeal to the High Court of Justice. But now at least I'm going to use the wording of the Israeli Supreme Court and say that even if 1 year or 2 years after the amendment was passed and confirmed, the court said that it is still not the pace, or the time hasn't really come in order to come and examine the measures taken by the state. Now, after almost 9 years and after 12 or 13 years since the amendment was confirmed, we cannot say that there hasn't been a reasonable time that had passed since then in order to achieve the right to equality of Arab women. So I'm going to pause here, but I was thinking to bring another example which illustrates the conflict of the intervention of law and politics into the feminist movement, but maybe I will illustrate that during the discussion.
During the Q&A. Thank you very much. So I have two questions. My first question is directed to both Xianan and Hossam. What's interesting about your stories is that you each discuss retrenchment. Xianan, you refer to the going backwards over the last 10 years of gender progress, and Hossam, you talk about the retrenchment relative to 100 years ago. So you're both giving a story of a backward slide, if you like, as it relates to gender. I think, Xianang, you're referencing mostly gender in its most narrow vision of women, and Hossam, you're looking at a broader denomination of women, LGBT, and other movements that have flowed from the women's movement into other sub-minorities that are often classified under women in a fairly reductive and brutal way. So I wonder if each of you would like to say a little bit more about the reasons for the backsliding. And clearly there's a historical reason that you spoke about with colonial and post-colonial politics, but in the global context, which is what we're looking at, the last 10 years, 15 years, but especially since, I guess, 2008, we're very, very, very much feeling the effects of not just the financial crisis, but the politics of belt tightening. And usually in any sort of political discourse that talks about belt tightening, the first to go are what of those are political minorities, and women, children, LGBT are easily seen by the politically powerful as the politically less relevant. So not just the politics of belt tightening economically But also, you made mention, Hossam, as the other panel this morning did, about the rise of religious conservatism that is probably also connected to fiscal conservatism. So going forward, looking ahead, do you have any forward projections for the next 10, 15 years in your own country of how these three dynamics, gender, narrowly or broadly defined, economic downturn, and also the effect of religious conservatism, how are they going to affect the dynamics in your countries in the next 10 to 15 years? And maybe, Xianin, you'd like to start.
I think I just can't generally say the women's rights backward in the 20 minutes, the past 10 years. I mean, actually, in many aspects and many fields like education or other fields, actually there are very big progress in China. But I just talk about the attitude, and I think the reason just some traditional gender attitude come back. I think there are some reasons, like some reason is from the government. In the past, in 1950s, not only because of the Marxism, just encourage women to work outside the home, but also after many years war, China, we do need labor to work, and so the government to encourage women to go out to work, and it also have some just economic reason. But nowadays, too many laborers in China, so actually the government just doesn't have the the reason that in the past to encourage women to go out to work. And also because I mentioned, although China ratified the CEDAW and the other conventions, but the domestic law, I know I read the initial report from the government, Chinese government. Chinese government always talk about we enacted so many laws on women's rights or other issues, but actually I think a lot of concepts and spirit different, look similar, but if you read carefully, actually different. In women's field, in Chinese law, we don't have the distinction on discrimination. Although definition. Although so many Chinese law prohibit discrimination, but we don't know what really is discrimination, and also we didn't base on the human rights, the rights the people born with, and we talk about the lawful rights, and also we always treat women like children. We always put women and children together in China, and we try to give women some special protection because women are weakness in physically, and in Chinese women can retire, not can, it's a must retire earlier, 5 years or to 10 years earlier than men.
But they probably live longer than men, yes?
Yeah, but early retirement. And for the purpose of this law is to protect women and give women some benefit, because the people think women are weakness, and also women did a lot of work, housework for the family and contribute a lot. So, and the women need to take care of their family, husband, and the grandchild. So, it's a kind of benefit. But actually, I think we debate this for about 20 years. Some women just think, it's a big obstacle for women to get a promotion, and also, will cause some economic damage. Actually, if you retire early, actually the income is much lower than if you continue to work. So I think it's also just because the government sometimes is misleading the public, and also I mentioned just it's in the the international human rights concepts is really brand new for Chinese society. So we need a longer time to understand and yes, accept this kind of concepts.
Thank you. And Hassan, the retrenchment in your country is disturbing, given that this is a moment when you would hope to find niches and spaces for great progress. You gave a somewhat pessimistic analysis of what's happening in Egypt. Looking forward over the next 10, 15 years, do you see things getting better, and why? Getting worse? Why? Where do you see things going?
I think things are great now and will continue to get better. I think we're dealing with the uncertainties of this, overwhelming change that happened in our lives, but I prefer these uncertainties. I much prefer them to the certainty of the stagnation and oppression that we had 2 years ago. I was trying to make a proposal of a strategy rather than give an assessment of where women's rights are right now compared to 100 years ago. And I think that we have made great strides. I believe. In terms of legal reforms, in terms of women having the right to initiate divorce, protections of some rights in the family, criminalization of female genital cutting, and also in terms of de facto discrimination. Women are now working as judges for the first time, although not fully on equal footing. On the ground, we have more female university students than male university students now, and women's participation in the labor force is increasing, even if their share in the economy is still refusing to increase, probably because of the belt tightening. So I think if we look at women in the social movement right now around the country, not just in Cairo, we will see that we probably have significantly enhanced participation in politics and in social movement compared to 2 years ago. But obviously in decision-making mechanisms, and precisely because immediately after Mubarak we had a year and a half of military rule, and women do not serve in the military in Egypt. So by default, there were no women in the Supreme Council of the Armed Forces, and the generals did not pick any women in any of the committees that they formed, and pretty much abolished the quota system in the national parliamentary elections. But so going ahead, I think more emphasis on community organizing, public education, on having the conversation, on making the case, so enhanced emphasis on this without, of course, stopping the very important work of doing policy advocacy and strategic litigation. I think it's really important that the struggle for gender equality is introduced as part of the struggle for democracy. And we keep trying to make this point that, when we initiated this revolution, we didn't do it just because we wanted a democratic government, but also a democratic society. So in addition to periodic and fair elections and separation of powers and accountability for public officials, we also want to live in a society where there is respect for personal freedoms, gender equality, and religious equality at a minimum. And that's something that we need to get better at. That sort of messaging and strategic communication is I think, something we need to significantly improve. And so in a way, the women's rights advocacy became very similar to the human rights advocacy, where you produce recommendations and then you hammer policymakers to implement those recommendations. And I think the human rights movement needs to go back to the way women's rights activists used to do it, which is to build movements. And a big part of this is going to be really engaging Islam, engaging Sharia, whether or not the party in power this election is an Islamist party. Religion is going to continue to play an important role in legislation and in public policy in our countries for a few years at least. And putting equality putting people in a choice between equality and Islam, in fact, forcing people to change between Islam and anything, people will choose Islam. They're not going to ask what the other thing is. And that's what we have learned in so many elections, so many referenda, etc. Even when really what's put to, and the political Islamists use this. I mean, when we had the first referendum after Mubarak, over amending some articles of the Constitution just to allow for elections in March of last year, some of the religious organizations managed to misinform the public that this was a choice between the old Constitution, which had Sharia as the source of legislation, and a new Constitution that will not have Sharia, which was a complete lie. But all the posters, all the signs everywhere said, if you like Islam, you have to vote yes. And as a result, we had 77% of the people vote yes. A big chunk of them were victims of this campaign of misinformation. So with information, I think we need to continue to engage Islam, engage Islamists, and really find the right way to neutralize the religious foundation of discrimination, but not by ignoring it, but really by
engaging with it.
By engaging with it, so that the enemies, whenever they are challenged on Sharia, they immediately reveal their true colors. So they would argue that no, women should not have the right to initiate unilateral divorce. And when you give them the evidence from Sharia that they're lying, then they say, but it would destroy families. Think of the children. Women should not have. Women are emotional. They should not be trusted with such big decisions like ending a marriage. And these are the arguments that we are very capable of responding to once you get religion out of the way.
Thank you. Rangita, my question is for you. You gave a lovely synthesis of the ways in which the women's human rights movement, if I can combine the two, has revealed the nature of the public-private dichotomy, focused on individual harm, whether it exists in public space or in the private space, focused on local and community movements, and taken those issues upwards rather than a top-down approach. And you gave, I think, a rightfully optimistic analysis of the way that women's organising has got real lessons for the human rights movement going forward. I wonder if you would care to reflect on critics of CEDAW, especially those critics who say that international law is a tool of men, that it's essentially a crystallization of Western imperialism, and point to CEDAW as having the highest number of reservations than any other human rights treaty. As a matter of strategy going forward, to what extent do you see those criticisms as something that the women's movement and the gender movement, broadly described, needs to engage? Or do you see that whole debate as somewhat passé? And I think the same thing has been said about the issues of customary and cultural practices, that we could argue about these things as being somehow intrinsic to culture and therefore have to be left alone, or somehow apart from culture and therefore needing to be exposed to legal and political regulation. We could argue about these things unendingly, unceasingly, and that an alternate strategy would just be to say those arguments no longer need to be engaged with. They're part of the 20th century, and 21st century strategy and discourse is simply going to move onwards. What do you say to that?
So what I was trying to say is that the international women's human rights movement has helped to change the traditional narrative of public international law as being a Western discourse and being a very top-down discourse. What I did not say is that the women's human rights movement is an ideal one. I feel it still has to go a long way in becoming more inclusive and becoming much more a dynamic tool, even within, even at the local level. And to that extent, I want to respond to both Sausan and Liu Xunan's arguments, because I think to some extent what they're trying to show is that the women's human rights movement can become much more participatory. And the way it is can be seen to be insular in some communities. And I think that is because the women's human rights movement came of age at a time when they had to fight to claim human rights, and therefore had to some extent become a homogeneous brand. But now it has come to a point when women's human rights will not have relevance unless you see that women are defined much more than by their gender, but by their race, ethnicity, ability, disability, residence, religion. And I think the CEDAW is still enormously relevant. The convention calls for special temporary measures, quotas for women, affirmative action, and women have won those triumphs and battles. But what we see in countries like Bangladesh, in Nepal, in India, and Pakistan, that still these quotas are occupied by a homogeneous group of able-bodied racial majorities, and that it's not truly inclusive, it's not truly universal. And what we're trying to do, and what these women's movements are trying to do, outward-looking women's movements trying to do, is that within those quotas to provide a quota for other minorities, for women with disabilities. So, for example, the 30% quota, the 40% quota for women in local government in Bangladesh has now been expanded to create a 10% quota for women with disabilities, because women with disabilities form 10% of women in Bangladesh. So it makes sense that those quotas are expanded to cover that. And moreover, what we see is that women are discriminated based not just on their gender. And a very poignant case is in Nepal's Muluku Ain, which allows men, the civil law of Nepal allows men to divorce their wives who become disabled during the course of the marriage. Now, there you see that this is a ground of discrimination based both on gender and disability, because women are not allowed to divorce a man who becomes disabled during the course of their marriage. So you need both conventions, the CEDAW as well as the Convention on the Rights of Persons with Disabilities, to challenge this. But moreover, the women's movement has to see this as a battle. It's not just something that concerns persons with disabilities, but women universally. So they have to see that whenever there's discrimination based on race or ethnicity or religion, it impacts all women and not just a particular group of women. And we have to make sure that we don't fall into that homogeneous trap that we challenge in men, in other dominant groups. So what I was trying to say is that the women's movement still has a long way to go in becoming more dynamic and relevant and inclusive. But the women's movement has helped to change the discourse of public international law, the way it was considered this Western project that was top down. And we see that in the ways in which women have changed the narrative. The pivot is no longer outside the realm of international human rights law. It is within the purview of public international law. And we've made sure that rape and sexual abuse is considered an act of genocide as a tool of war. And that is because of the struggle of the women's movement. You know, the way genocide and war crimes were defined were very much in the image of men. And so to redefine, to reconceptualize the laws of war, genocide, in ways that impact both men and women has really been another triumph for women's human rights movement. And I think the ways in which genocide now covers sexual abuse in conflict and in post-conflict, and the ways in which women, Security Council 1325 calls not just for women to be at the table post-conflict in drafting peace treaties, but 1820, which calls for abuse against women, sexual abuse, violence against women to be considered a war crime, really shows that women are continuing to change the way in which public international human rights law is being defined and narrated.
So, San, what do you think about this idea of having a quota for Palestinian women as a subset within boards of directors that have to have quotas for women?
Yes, this is actually a question that I myself is very much struggling while writing the petition to the Supreme Court. I think that I tend to decline on having lobbying or advocacy to have a quota for Palestinian women as such, because I think that it will then illustrate the division between the women themselves and it would illustrate more the differences based on nationality, where such differences, especially on quota issues, should not exist. There is no cultural issues, there is no religious issues, there is no other really relevant, unique, legitimate basis that really can come to justify such a division between both Jewish women and Israeli women. And if it does pass, then it will just, I think, help to marginalize the status of the Arab women, as if they need a unique and special quota in order to be adequately represented in the board of directors. Again, we're not talking about adequate representation even for Palestinian women in the Ministry of Religion, let's say, or in the Ministry of, because the Ministry of Religion is also as well responsible in Israel on the previous Minister of Religion, now it's the Minister of Interior, but it is responsible on the family courts. So we're not asking about adequate representation for Palestinian women in the Minister of Interior, in the department that is responsible on the religious court. We are not asking for adequate representation for issues that are relating to institutions that are relating to the Arab minority. We are actually dealing with an amendment or a governmental organization or governmental companies that give services to all the population. We're talking about the postal office, the port office, the oil governmental company, the train governmental company. So we're talking about civil, about governmental corporations that provide and should provide equal services for everyone. So to come and, in this case, divide, to come and put a unique, make the Palestinian woman a unique group, I think it only, this is not the right place, first of all. And second of all, it illustrates the division. And as I said, it marginalizes more and more the Arab women, where in fact there should be equal implementation. Because when we have such a case as the one that I presented, we're eventually talking about equal implementation of the law, which is equal protection of the law. And when you have a law that is being implemented on a specific group based on its nationality and ethnicity, which, by the way, in a state as defined as the state of, as it is defined as a Jewish and democratic state, and when you have laws that are being implemented only or mainly on this group, which is how do you say, incompatibility with the definition of the state, then I think that you have a huge problem of legal problem of equal protection of the law, taking into consideration that Israel also defines itself as a democratic country. So when you have a problem in the equal protection of the law, which is the basis of based on the right of equality, which is the basis of every democratic state, and this is the principal value in every democratic state, this should pose a very big question on what kind of values this democracy includes, when the really main thing and the basic thing as the equal protection of the law is not taken for granted, and it is even institutionally and intentionally not being implemented.
Okay. Now, Titi, it's 1 o'clock. I know we started late, but all of these panelists are going to be out there having lunch with you, so I'd like to encourage you to come and have a conversation with them at lunchtime and to help me in thanking them for their presentations.